evening, everyone, and welcome. Thank you to Judge Anders, Judge Schulman, and the rest of today's speakers for planning this informative program. The Philadelphia Bar Association is proud to host this webinar as a service to the entire legal community. I'm Jen Coatsworth, the 2024 Chancellor of the Philadelphia Bar Association. If you are not yet a member of the association or have let your membership lapse in recent years, please consider joining or rejoining for member-exclusive programming and benefits that will further enhance your practice. Our state civil litigation section has formed a strong relationship with the First Judicial District and offers monthly town halls with updates from the courts, along with periodic CLE programs on the latest trends and top-of-mind issues in the practice area, including trial skills, case management, best practices, and more. The section also has a medical legal subcommittee that focuses on the interplay between the medical and legal sectors and the latest legislation impacting medical malpractice cases. We also offer plenty of unique opportunities to interact with the judiciary and your colleagues in a social setting, including regular happy hours and our annual bench bar conference. You can learn more about the benefits of membership at philadelphiabar.org, and you can also reach out to me directly if you have questions or would like to learn more about the association's work. My email is chancellor@philabar.org. Have a wonderful evening, and thank you to the judges and participants, and I will now kick it off to Judge Anders.
Chancellor Coatsworth, thank you so much for hosting this session today. You've been, and the entire Bar Association has been very supportive of our efforts in the last 3+ years to bring together the medical malpractice community to get better case management results in Philadelphia, and we're so proud to have you. And also, I think probably ending or near the end of your chancellorship with going out with a bang. Let us get to the program here, and I'm going to share my screen. We have several speakers today. Of course, we have Judge Schulman, the judicial leader of the medical malpractice program, two leading practitioners, Jim Beasley and Carolyn Bohmueller, Clare Bello, who is the enterprise director for claims and insurance at Jefferson Health, and then Beth Persun, who's the director of claims administration at MCARE. Judge Schulman and I will spend a little bit of time providing you an update, both a look back at 2024 and a look forward to 2025. The two attorneys will give some firsthand experience, especially for lawyers who are newer to practice in Philadelphia, or at least in the medical malpractice program, about how to comply with our protocols and the opportunities to settle cases earlier. Jefferson's Clare Bello will talk about Jefferson's approach to claims management and resolving cases earlier, as well as addressing discovery issues. And then we'll finish with Beth Persun, who will provide a statewide perspective on medical malpractice claims, as well as MCARE resources that are available to resolve these claims. I'll start with the biggest impact that has occurred, at least in Philadelphia. And as a result of the venue rule change from 2023, we have experienced an increase in filings in Philadelphia. In 2023, we had 544 cases that were newly filed. This year, we're on track to reach about 600 case filings this year. If we look at what that was before the pandemic, it's a 46% increase from 2017 to 2019. And even in the 1 year since the rule change was enacted, it's a 10% increase from 2023. In 2024, we have consistently given earlier trial assignments than we did previously. 90 days if there's no reasonable offer made by the defendant at the pretrial conference, or confidential authority communicated to Judge Schulman to settle the case. And if you don't have an offer or that confidential authority to settle the case, then you are going to trial within those 90 days. But if you have either one of those, we're going to give you some breathing room to try and settle that case, and we'll give that case a little longer trial date generally within 6 months. There are exceptions. If it's an exceptionally longer case, you might go a little bit further out. But generally, we try and do our best to schedule it within 6 months. In 2024, we also experienced significantly less cases that were scheduled each week to trial. That is in part a reflection of the lower inventory that we had in 2021 and 2022. And so in contrast to the 10 to 12 trials that were scheduled every week towards the end of 2023, through most of 2024, we were scheduling 4 to 6 trials each week. In terms of the verdicts, in 2024, there's a 73% defense verdict for those who actually went to a jury verdict and 27% plaintiff verdict. That compares with a 10-year average of 63% defense and 37% plaintiff cases that actually go to a jury verdict. In terms of the number of settlements, we've continued to see a higher number of cases that have been settled. That's again a reflection of our overall inventory has grown. But we also think that all of the mechanisms that we've put in place to settle cases earlier has resulted in that higher settlement rate. If I look at the verdicts in more specific terms, numbers, 2024, there were 7 plaintiff and 19 defense verdicts. What's notable, among other things, is that in 2024 year to date, we had 26 cases go to verdict. That's the most amount that we've had go to a verdict since I've been keeping records for at least the 10 years. And in those verdicts, there's certainly a notable verdict of $44 million, but also I'll just point out that 3 out of those 7 plaintiff verdicts were under $1 million. Now in 2023, there were 19 verdicts that went to trial, and those were 10 plaintiff, 9 defense. So the ratio was upside for the plaintiff, and you can see the verdict amounts widely ranged all the way up to $182 million to a low of $250,000. Looking ahead at 2025, what do we expect next year? I would expect that we'll have a leveling off of the new medical malpractice filings, probably somewhere in the range of 50 per month. That may change, of course, if there's additional hospitals that are added by a particular hospital system. But my guess is that we're going to stay relatively consistent in that 50 per month. The notable change for 2025 is we are going to increase the number of pretrial conferences and trials to ensure that all of our cases are moving forward timely. And by March of 2025, the first group of cases that were filed after the new venue rule change in January 2023, those cases will now be ready for pretrial conferences and then subsequently trial. So although we're currently doing this month and last month 12 to 15 pretrial conferences per month, by March 2025, we expect that number to increase somewhere between 30 to 35 pretrials per month. And then, of course, following that, the number of trials scheduled per week will also increase. Currently, we're doing 4 to 5 trials per week that are scheduled for a trial, and we're going to likely increase that to 6 to 8 trials per week. So as busy as we are now, and I recognize that lawyers are certainly busy, clients are certainly busy, I believe we'll get busier in 2025. And that is our effort is to keep this, despite the increased inventory, we want to keep it current. And to do that, we're going to have to increase the number of pretrials and trials scheduled. In terms of the length of time from the pretrial conference to the trial date, generally we anticipate holding within the same 2 parameters, that if you have no offer or no confidential settlement authority by the defendant, we'll do our best to schedule you within 90 days. And if you otherwise had that offer, we're still going to do our best to schedule you within 6 months. Double booking of trial counsel, that will continue until and unless more cases settle before the pretrial conference. If we don't have to schedule a case for trial, obviously the number of pretrial conferences will be reduced and the number of trials scheduled will be reduced. But that's been an important tool in our ability to keep current. In terms of the actual attachment, we will not interfere with a client's relationship with their lawyer. So if Clare Bello, who has many wonderful lawyers who represent Jefferson, has the same lawyer that's attached in two cases, we will not require Clare to pick between which trial attorneys will try that case. The earlier attachment order controls, and the later attached case will be continued if they're still attached as of the day of trial. That has, in practical effect, only impacted about 1% of our cases, which means that the later case was continued. We've had a few other instances where a trial attorney is concluding another trial, and jury selection in those cases may be delayed for a few days to accommodate the trial attorney who is concluding another trial. But what that also means is that trial attorney may be going back-to-back jury trials. I want to pause just on one comment, and the lawyers were very helpful and said, what are some of your pet peeves that we have as judges? And I will tell you, one of mine is the number of John or Jane Doe defendants that are named in complaints. And if you read 2005, it's the naming of unknown defendants, but I think a better title of this rule is known but unnamed defendants. And the official comment is very clear. Do not designate a Doe defendant as a placeholder. That is not a valid use of Rule 2005. And so I see a lot of complaints that come in with John Doe's 1 through 10, ABC Health Corporation 1 through 10. Those are inappropriate uses of the rule, and it is not intended to be a catch-all. So please do your best to adhere and comply with Rule 2005. It's not the same as the New Jersey rule. It is only where you know that there is a defendant, but despite your due diligence, you are unable to discover the name of that defendant, is what will save and preserve your claims in Rule 2005. And then one last thing I wanted to address is the terms of transfers of out of county for either venue or forum nonconvenience. And despite the rule change in 2023, we continue to transfer cases out, medical malpractice cases out, based upon either venue or forum nonconvenience. Year to date in 2024, there's been 24 cases that have been transferred to other counties. And historically, from 2017 to 2024, it's around 19 cases that are transferred. That number being 24 is likely indicative of the more cases that are being filed here as opposed to historically. And with those friendly comments, I'm going to turn this over to Judge Schulman.
All right. Thank you, Judge Anders, and good afternoon to everybody. So I'm going to review with you all the different interactions that you'll have with the court once you file a medical malpractice case. So the first interaction will be at a one-year conference, and I hold those. I also get assistance from JPTs, Peter Hoffman and Madeline Sherry, because as you can imagine, there are a lot of one-year conferences that get held. So the purpose of the one-year conference is essentially to see where you are with your discovery. And, you know, it runs the gamut. Some people at the one-year conference are already well into taking their depositions. Others have just sent out written discovery and have not started scheduling depositions. And my advice is that certainly by the time you have a one-year conference, all of your written discovery should be answered. You should be scheduling depositions, at least getting them on the books. And even if you don't have every single last piece of written discovery, Still get that scheduling done, because you know how difficult it is with lawyers' schedules, doctors' schedules, canceling, rescheduling. So it's very important to get those dates on the books. The other major part of the one-year conference is that you must file a one-year conference memorandum. Lately, I've been seeing a lot of cases where those one-year conference memorandums are not being filed, and that will probably end up with a cancellation of your conference. So please make sure that you do file them. They don't ask for a lot of information. It's very basic. But what we do want is a demand from the plaintiff. And again, I still see some that come in without a demand. If that happens, your conference will probably get canceled. The reason for this is that the demand starts the settlement process off. So we want to start it as early as possible. It's helpful for defense counsel to have an idea of what ballpark you are in, and it's helpful for the court to know whether or not this case may more likely move to settlement. Also, I would say consider at the 1-year mark whether or not you can let out a resident by agreement without prejudice, because oftentimes residents are named in the complaint. It's very disruptive to their lives, their careers. Where possible, you can let a resident out. I'm sure it would be very much appreciated. And you can do it without prejudice. So if after discovery you need to bring that person back into the lawsuit, you can. The other thing I wanted to mention is that with the increased volume of cases, of course, there are increased preliminary objections, increased motions for summary judgment, and those are a burden to the judges who are spread out amongst the different teams trying to get your motions decided. So be deliberate when you file these motions. If you don't have to file one, don't just do it as a knee-jerk, because the less you file, honestly, the greater chance you have of a judge looking at that summary judgment motion and really being able to take the time to review it thoroughly. Just a word about that. The next time you will see me will be at the pretrial conference, but I'm going to I'll just dwell on these items before I get to the pretrial conference. We have a built-in conference 90 days before your trial is to commence. That's going to be primarily with Pete Devone, and the only reason for that is to find out whether or not the case is right for a JPT settlement conference. So let's talk about the JPT program. As most of you know, but some of you are new to the program, we have about 21 extraordinarily experienced medical malpractice attorneys who serve pro bono as JPTs, as well as our two senior judges, Judge Lockman and Judge Glazer. And just for an example of the quality of the attorneys who serve as our JPTs, Rob Sachs, Steve Wigreiser, Jim Beasley, Tim Lawn, Lenny Valori, Bobby Puccini. These are people at the top of their game on the plaintiff side, on the defense side. Bill Banton, Dan Ryan, Dan Sherry, Peter Hoffman, Kathleen Kramer. So these people are incredibly experienced. The success rate is phenomenal. So just to share with you yesterday an anecdote from Joe Bongiovanni at Post and Shell. He had an early JPT conference. before the pretrial conference, I believe, with one of our JPTs who just stuck with the case and stuck with the case until the case settled early. And now Joe is going to be using that JPT privately for private mediations. And that's what we want to see happen. We want to get you to them as early as possible, but there's one stumbling block to getting to a JPT settlement conference, and that is a reasonable demand and a reasonable offer or confidential communication of settlement authority that you can make to me. So I'm the gatekeeper between yourselves and the JPTs. Obviously, these JPTs are very busy people, and we are so appreciative, but we don't want to waste anyone's time. So if you don't have authority from your client to negotiate in earnest, you should not ask for a JPT settlement conference. If you do have that authority, you can contact my chambers at any time during the litigation, anytime. It's never too soon. It sometimes could be too late, but even Don Cami, Dan Sherry, they will at times jump right in at the last minute in the 11th hour and see if they can't get the parties to resolve their differences. And more often than not, they do. So it's a tremendous program. I don't know of anywhere else that you have that opportunity. It's free of charge. So it's a really excellent opportunity. The thing we don't want you to do is be calling Pete Devone directly to request a conference, because he doesn't have time to do the vetting that needs to be done. I do, and I'm here to do that for you. Moving on just to the trial readiness conference, that's going to take place, and I also do those on either the Monday or the Friday before your jury selection. So you are days away from trial. We're going to talk about the number of motions in limine. If you have more than 6 motions in limine, I'm going to ask you to prepare just a brief memo that prioritizes the motions for the trial judge. You won't be assigned to the trial judge yet, but you'll send that memo to me and I will pass it on to the trial judge, or you can pass it on to the trial judge, so that, when the trial judge gets the assignment, which is on Wednesday before you're picking the jury, there's precious little time to be working on those motions in limine. So, sometimes there are cases where there are 20, 25, 30 motions in limine. A trial judge needs to have your cooperation in prioritizing and withdrawing the motions that don't need to be decided any longer. At the trial readiness conference, trial counsel must attend. You cannot send an associate. This is the point in time where trial counsel must attend. I will sometimes discuss settlement with you in detail if I think that will be useful. So it's a very important conference. And now we can move just to the protocols for the pretrial conference. Your pretrial conference is where you get your trial date scheduled. So the pretrial conference obviously is an extremely important measure. The pretrial conferences will only get scheduled once you have filed your certificate of compliance that all sides have exchanged their expert reports. This is a departure from what used to happen in pretrial conferences, because what we find is that if the parties don't have their exchange of expert reports, defense counsel is not going to be able to talk to you about settlement because they won't have authority to do so. What we have done is built in a 3-month period of time before the pretrial conference that your clients will have the expert reports in hand to review. We were asked to do that by the academic medical centers. We have done that so that there's a 3-month buffer between getting the expert report and getting to a pretrial conference. But what I expect, what we all expect, is then at the pretrial conference, when I ask what the defense position is, I am not expecting the answer, well, we still need time to review the case. We are working so hard to avoid that being the standard answer. What we are working toward is a definitive statement in response to a reasonable demand. So by a reasonable demand, you all know what your cases are worth. And of course, you're going to make a demand in excess of what the true value of the case is as you see it. Make it reasonable. When I see somebody who starts out with a $20 million demand, and by the time they get to the pretrial conference, it's a $60 million demand, that's not going to be reasonable. We all know that. If you're looking for $1 million and you're making a demand for $20 million, everyone pretty much that works in this program, the attorneys, the hospital administrators, the insurance adjusters, are very experienced in valuing your case. So becoming reasonable is it may be a word, but it's very, very important to take this seriously. As well, and I will talk to plaintiffs' counsel when I think that a demand is not reasonable. I will ask them at the pretrial conference to make your demand reasonable so that it will start a settlement discussion. What you don't want is when you have that unreasonable demand and the response to the demand is unreasonable, we are not even going to negotiate. That's not a desired response, right? So on the other side, what we want to hear from the defense side is, we have your demand, we have your expert reports, we are ready to negotiate, we have authority that we can communicate to you, Judge Schulman, privately, and that will be in a private discussion on the Zoom, or we're prepared to make an offer. And as long as those two things are done, I will be more than happy to send you to a JPT so that you will have time before you go to trial to try and resolve the case. If the case has to be tried, then that's the answer I will expect as well. No, Judge, we're not going to negotiate on this case. This is one that has to go to trial. Perfectly fine answer, but that case is going to go to trial as close to 90 days out as I can make it, because that's the case that's ready to go. There's nothing standing in your way any longer. Those are the cases that we want to get on the calendar within 90 days, where reasonably that can happen. It's not a hard and fast rule, but you're not going to get a 6-month date on that kind of a case. So let me just jump then to where we do have to double book. Plaintiff's counsel will be given a choice in that instance at the pretrial conference. If the defense counsel is booked, say for 6 months out, we will double book that person. But before I do that, I'll ask plaintiff's counsel, would you rather take a double booking, or would you rather wait and get a fully clear date for that attorney? The reason for that is, if we have a conflict when the case comes up for trial, as Judge Anders said, the first booked case takes precedence. We also have our 5-county agreement. So that's among all the counties. We all honor that agreement. And I will not book a lawyer if that lawyer is already booked with in another county. So it will be plaintiff's counsel's choice. What that means is that possibly when your trial comes up, you could get bumped. And then we are going to work out a new trial date with you. So it's the choice that is provided to you. We're aware it's not optimum. We'd like at some point to stop double booking altogether, but I don't think that that's going to be happening yet. The other thing and the final thing I want to talk about is notice to MCARE. And Beth Persun will talk about this. I'm not going to dwell on it, but something new at the pretrial conferences, I am going to ask you whether or not notice has been provided, and where notice has been provided to MCARE, that you send your pretrial memo in the case, both sides, to MCARE. All right? That way, when it comes to crunch time, if there is a tender made, they already have the materials at MCARE, and they're not scrambling to try and get what they need to evaluate the case. So as far and I want to just double back on the certificate of compliance. If you have your expert reports exchanged even the day before the rule hearing, so, and just for those who don't know, if the certificate of compliance is not filed in a timely manner, and we know based on the case management order when that certificate should be coming in. If it doesn't come in, you're going to be scheduled for a rule hearing where sanctions may be imposed if you fail to comply with the case management order that was issued when the case began, or if you got an extension of time at the discovery phase, you get a new case management order with new deadlines. If you have had multiple extensions of time from a judge in one of your team leaders in a discovery matter, you should most certainly not expect that you're going to get any extension of time for your expert reports. Only extensions of time, pretty much virtually, is where either an expert or an attorney has become ill, or an expert passes away and you have to replace an expert. But just because discovery isn't complete or things of that nature, those are things that have to have been dealt with before you get to me. So you should not expect to be filing motions for extraordinary relief for extensions of your expert reports. They most likely will not be granted. If you exchange your expert reports even the day before or the morning of the rule hearing, if you notify my chambers, we'll cancel the rule hearing and you won't have to show up. So we do much, much better now. When we started rule hearings, I was doing 15 to 20 a month. Now it's more like 4 to 5, which is fabulous. We know that that's really hard for you to do. It takes a lot of hard work, and you all are doing it for the most part, and we appreciate that a great deal. So I think that's where I wrap up. Thank you.
Thank you, Judge Schulman. I'm going to go relatively quickly through the next slide. You will have these. If you have a petition that needs approval by the Orphans Court, make sure that you get a letter from DHS indicating there's no objection. Just take a look at that slide. In terms of settlement, notice of court of the settlement, the best way and the fastest way is to notify the court via e-filing in the conference submission section and replying to the trial assignment. But e-filing the settlement letter is the best and fastest way to notify the court a matter is settled. Do not wait until the settlement agreement has been fully executed. Do not wait until the petition to approve settlement has been approved. Once you have reached the material terms of settlement, the case is settled. And let us know as soon as you can. That will allow us to assign cases earlier to trial. And that is what I have. So we're going to pass this on to Carolyn Bohmueller and Jim Beasley. I know they have a lot of great practical tips.
Thank you, Judge Anders and Judge Schulman. We appreciate it. Jim and I have been asked to talk about practical tips. Mostly, I think it's going to be beneficial for those folks who don't normally practice in the Med-Mal program, but hopefully some of the tips will spill over into those who do practice regularly in the Med-Mal arena. I am just going to share my screen here. Hopefully you all can see that. Is that it? Can you see it?
Yeah,
yes.
I can see.
Okay, good. So the first thing we want to talk about is in the Med-Mal world, there are very specific rules. Judge Anders mentioned one of the newest ones, which is the new venue rule. But there are also specific rules about certificates of merit and what needs to be filed. And there are qualifications for the experts who need to support those certificates of merit. And it's very important to be familiar with all of those. It has its own unique set of rules. And if you're not following those, you can find yourself in a little bit of trouble. I don't know if, Jim, you wanted to add anything on that.
Yeah, the certificate of merit is really no joke. If you're going to file a medical malpractice case, you need to make sure that you've got the proper guidance. So getting a certificate of merit shouldn't be a requirement. It should be something that you do as a matter of course. But if you don't have the proper expert, and you have to become aware of the case law out there, because there are exceptions. It's not as rigid as Jersey, for example. Your case doesn't end well, the defense can request all of your information regarding spoke with and the certificates themselves. And one, they were properly filed, and two, they were filed by a qualified person. You can end up being charged with all the costs that are associated with the defense dealing with that particular issue. So it's a real thing. But from a practical perspective, you want to make sure that you're speaking with the smart people who can provide guidance and get you the information you need so that you bring the claims you have to.
So one of the things we wanted to point out is the Philadelphia court and Judge Anders and Judge Schulman have done a phenomenal job of really creating this medical malpractice program specific for the unique needs of our cases. And if you go to the website down here on the bottom of the PowerPoint, you can find a lot of information, a lot of very useful information that you should know and be following. And you'll find a specific tab for the medical malpractice program. And under that tab, you can find the events workflow, you can find the case management order, 1-year status conference, all of the prerequisites that you need in order to move your case along in the Med-Mal program. There are forms that you can follow and must follow. So there's a lot of important information there that you should be aware of. The one thing that I wanted to mention too is the case management conference. Judge Schulman had mentioned that at the 1-year status conference, it's important to have your reasonable demand. But I also wanted to point out that at the case management status, which is, I think 90 days after the case is filed, a couple of different things happen. And one of them is if your complaint is not filed by the time your case is scheduled for the case management conference, the court can and usually will issue its own rule to file complaint. So even if you have an agreement with defense counsel that, hey, I'm still gathering information or I need discovery or something like that, I think it's best to file a stipulation with the court so they know that there is an agreement among the parties. With the case management conference memo, the plaintiff also is required to put in their demand, but the defense is also required to put in our insurance information. So be sure to have your insurance information in that memo.
And the other thing that's important with that memo, and it goes towards, from the plaintiff's perspective, you have this case, you potentially have, 2 years, if not more, if it's a minor, to get everything together. When this claim or the writ is dropped, the defense is just getting information. So they're going to have a bit of catch up to do. But part of that memo requires you to identify any lost earnings, liens, anything from workers' comp to ERISA to medical. Get all that stuff done early in your investigation and find out what all that is, because one, you got to put it on the form, and the court is not happy to see like a TBD or unknown or whatever. If you've got enough information to put the complaint together, you should know whether the person has lost earnings and whether there's a medical lien. So get ahead of that now. And that's going to touch, when we discuss things later, many times you're not going to be able to settle the case without a lien letter. And if you come to the end of the case and you've got it settled and the defense asks for a lien letter, the person's like, oh, geez, I didn't research that. You're actually, the defense is not going to pay it, because they can get jammed for the lien requirements under some of the laws. So get all that stuff done ahead. The memo is complete, because it's going to save us later.
So as Judge Schulman went through the different conferences and the deadlines, will be all, once you get your case management order, all of that will be set forth. The 1-year status conference, the discovery deadline, the plaintiff's expert reports, and the defense expert reports. And as Jim said, just remember that the defense is often playing catch up. And, if you're filing or serving your discovery within, as soon as the complaint is filed, we need some time to get that information, because we don't know anything about the case at the time. We need to gather the information. So just be patient. But in general, the court does give about 19 months for discovery.
Yeah, and kind of again along those lines, I like to practice. It doesn't always happen, but I like to practice really every case. But assume you're in federal court and you're running Rule 26. Get your initial disclosures ready. Get your records, follow up, subsequent records. Get all that stuff bait stamped. There's no reason to not share that with the defense. Get that information together and get it out, because that's going to help the defense get the case ready, at least to be evaluated and to determine maybe if there is an early resolution. I mean, if you wait until they have to file a motion to get all the records or the names of the providers, you're not doing yourself a service.
And then these are just some more dates of, as the case progresses along. One of the things we wanted to talk about too, and I don't know if Claire might touch on this as well, is, well, first of all, it's the medical malpractice bar is a pretty close bar. We know one another, and you hopefully have good rapport and relationship with one another. And it doesn't hurt to, and that includes not only the attorneys, but also the other members of the community, the leadership in the institutions. And it doesn't hurt if you reach out to somebody and say, hey, I'm going to be filing a lawsuit. Is this something you want to talk about? As Judge Anders mentioned, when a healthcare provider is named in a lawsuit, it has ramifications. It's not as simple as somebody's been named in a lawsuit, and if they're dismissed in 10 months or 18 months, it goes away. For the healthcare providers who are named, that follows them throughout their entire career. And so if you can at least have a discussion with somebody on the opposing side, figure out who you need to name, who really are the players. It can go a long way and have a good feel in developing the relationship with the opposing side. Same thing with settlements. Settlements have an implication for the healthcare providers. It follows them through their career. Just because it was 20 years ago doesn't mean that that provider ignores it when they're applying for new credentials or insurance. It follows them throughout, so it does have implications.
The other thing, just on that point, it is a good idea to reach out before you end up naming 15 different healthcare providers, including residents and nurses. I know a lot of times people like to do that so they can get jurisdiction over a resident if they're good. But make the call and ask. There are a lot of institutions that end up employing or will admit agency with the healthcare providers, and that gives you a couple of benefits. One, if it's not compromising the coverage and you don't need to name the person, there's no reason to do it just to give them a hard time. But secondly, chances are you'll have less lawyers involved. And so if you end up naming 15 people in a lawsuit and you end up with 5 different lawyers, well, the defense is going to be able to repeat the same defenses 5 times. The jury's going to forget what you said. But if it's just one plaintiff's lawyer versus one defense lawyer, and there's still the same effective coverage and you're still covering the same issues, you're going to have a trial in a week instead of 3 weeks. And that means you're going to get a trial date faster, which means you're going to get the case resolved faster.
Another thing that we've been, everybody's been talking about is staying ahead of your deadlines. Cooperate with opposing counsel, and that's on both sides. Everybody's busy, and as you can see by the statistics that Judge Anders put up, there are a lot of cases out there. There's a huge inventory, and everybody's working their hardest, including the institutions, the physicians, the insurance companies, to get through these cases and properly deal with them. So cooperate with opposing counsel. And this next point is one that Jim just mentioned about thinking carefully about who you sue and who is needed in the suit. Of course, comply with the court deadlines. The court is not unreasonable. And if you should need additional time because you find that there is an abundance of information that you didn't know that you were going to need, you just need more time for discovery, it's important to file the petition or motion for extraordinary relief before the discovery deadline has passed. I think Jim has already mentioned about preparing your discovery, getting your information ready. As I mentioned, the defense needs time to gather that information. There's a lot of information to be obtained. And don't file boilerplate discovery that has nothing to do with the case. No 2 cases are alike. There is a lot of information that you need to begin with, but you don't need to be asking for every nook and cranny if it's not going to apply to the case. And Jim, I don't know if you want to talk, you mentioned the federal court.
Yeah, I just think that I think that having meet and confer on issues more likely than not can get things resolved. If, for example, you really need an audit trail, that can be sometimes very cumbersome for the hospital to get together. Sometimes you need it, talk about it. If you have a case where there's no issue of alterations of the chart, there's no issue of who accessed the chart. And most of these cases, by the way, really turn out from a liability perspective just to be about a couple of pages anyways. So if you don't really need it, I will sometimes have a discussion with whomever, like I'll call Carolyn and be like, hey man, what's going on? Can we talk about this or that? Do I really need to have access to everybody who is in the chart at a certain time with the audit trail, for example? Many times it's critical. Those things sometimes can make your case. But if you don't really need that, you don't need to in the hospital with it just because it's all part of your boilerplate discovery. I don't think it's necessary. So I really try to put my discovery together when I'm writing the complaint. And I try to do my complaint at a single subject, single predicate, so it's easy to answer. It almost becomes a request for admissions there anyways later. And it just makes things much more efficient, and you're not spending time in motion court just burning energy.
I can just jump in terms of policies that a hospital may have. You don't need every policy. You may not need any policies, but if you don't need to ask for every single policy that was in effect at the time of the incident. Just be narrow and focused. If you need their informed consent policy, then just ask for the informed consent policy. You don't need the safety policy or hazardous materials policy. And then the other thing I would also add is that in terms of naming witnesses or taking parties' depositions or witness depositions, all of your experts are going to have to review all of those depositions, and it will spiral out of control with experts spending more money on experts that ultimately they may not have to read those deposition transcripts.
Your Honor, that's a good point. And what I will do in terms of policies is that normally if there's something I'm thinking about, I'll just ask for the table of contents. And then there's an intranet as well. And you just ask for the table of contents on those particular issues. Usually you get a screenshot of that pretty soon. And if there's something in there that seems reasonable, then try to get it. If you're having a fight about it, you're much more likely to get your motion granted if you can show that you attempted to work it out, you had a meet and confer, you got the table of content policies, they won't give them to you. You're much more likely to actually get them, to have a list of, I need every policy that was in effect in 2023.
And to Judge Anders' point, if you're asking for, and we've seen this quite a bit recently, the depositions of 30 different people, it's not easy to find those people, schedule a time to meet with them, find out what their schedule is. It's near impossible. And what it ends up doing is taking the focus away from actually looking at the case and evaluating liability, because you're too busy looking at all of this other stuff and trying to find a needle in the haystack rather than focusing your efforts on, what is this case really about? So be careful and thoughtful in the discovery.
Yeah, and just one more thing on that. I'm not trying to waste too much time, but just because you can take a deposition from a plaintiff's side doesn't mean you want to. 4020A5 allows healthcare providers depositions to be read even if they're available. So and you can end up taking a deposition of someone that ends up torpedoing your whole case because their testimony ends up getting read later at trial, and there's nothing you can do about it. You can't call them back, or it's going to be much harder to call them to cross-examine them on some of those issues. So just because you can pull a trigger doesn't mean you necessarily always should.
And the next slide we've already touched on, motions to compel need to be filed before the discovery deadline. The court is too busy to be dealing with frivolous motions. So as Jim pointed out, try to work it out and only file motions when absolutely necessary. Jim, if you want to touch on this one.
Yeah, it's kind of what I said before. Before you file, you need to talk to the people who actually know the nuances of your claim, because as a practicing attorney, you may be very experienced in these types of cases, but that doesn't mean that you're going to know what the particular standard of care is, or whatever. Get your experts ready, make sure that you have the information to do the complaint. And then also, just, excuse me, the sooner you have your experts, even in a 408 format, it can make it easier potentially for early resolution. If you can say, hey, listen, here's the report I got. It's a 408 report. Let's talk about this, see if we get this thing done. If you wait until the expert deadline to get all the expert materials, whether it's liability or damages, you're not going to be in a position, if there's an opportunity, to get the case done sooner. And we'll talk about this with the JPT in a moment, but the court has done an extraordinary job for our sakes. I mean, for the court's sake as well, but for the practitioner's sakes, to make this efficient. Anybody who remembers pre-day forward and pre-day backward, uh, will appreciate how hard the court has worked. And we want to be doing our best in order to make sure that if there's an opportunity to remove a case from the docket, it should be done so that the cases that actually need a jury use that jury, and you're not wasting the time. And also, as a plaintiff, it's good because you get paid sooner.
And so that ties into the whole settlement negotiations and being reasonable, as Judge Schulman talked about. And the JPT conferences are much different, and Jim can speak to this, than the old program where it was an automatic settlement conference. The JPT program now, you have to ask for it. And Judge Schulman explained that process. But if you're going there, you better be serious about talking. It's not just to go and see all your friends and say hi and go in and out. It's serious, it's substantial. And Jim, you can talk about the process as a JPT.
Yeah, there's a whole bunch of experienced folks on both sides of it that are really dedicated, again, to cooperating and working with the court to get the cases that need to be resolved so that we're not wasting juries, even if it's just, somebody used to use it as a negotiating tactic. Everybody digs in. Everybody wants to understand what the claims are, because the more that we can understand what both sides are, and there's obviously confidences and people won't share anything that they're not asked to. But if you're making a claim for a particular set of damages, give us the information, because it's going to make it easier for us to go to the other side and say, yeah, we've got 5 legitimate wrongful death beneficiaries here, and here's why, and here's what their losses are. We have I'll give you an example, a recent one, conscious pain and suffering that it's real, and here's the evidence for it. So there's a significant survival claim. Or let's look at what are the damages for emotional distress. All those types of things. Help us help you, because the more information you share with us, the more we can help. There's no secrets in these cases, especially when you get to the JPT time period or the trial. I mean, maybe you're going to have cross-examination stuff for an expert that you want to hold back, but in terms of the facts of the case, there's no secrets, and it doesn't make any sense to try to withhold something to make a point, because everybody knows the file. Everybody's going to know every record. And if there's something that supports your damages or your liability claims, let us know. If there's something that supports the fact that there's claims for a case or a particular set of damages, let us know that too, because then it's easier for us to help everything be realistic and get these cases off the docket, so we're not using jury pools in an unnecessary fashion.
And to that point, if the JPT can bring up information that perhaps hasn't been shared with the defense or with the plaintiff as of that time, it can help on either side. It's going to help us from the defense perspective say, oh, well, we didn't know about that. That might change our perspective. So it's important to bring that information to the JPT, and the JPT will, as long as he or she is permitted to share the information, can share it with the opposing party.
Yeah, and just because it doesn't get done on the first, we're all sticking with it. So a lot of times I'll pause it, be like, you guys got to go talk. You got to figure this out, or I need this information, I need that information. And then we reconvene. So once we're in until we're told to get lost.
One of the things we wanted to mention, I know Beth is going to be talking about the MCARE perspective, but from the plaintiff's side, make sure that you're aware that there is an August 31st deadline, and anything settled before August 31st is going to be paid on December 31st of that year from the MCARE fund. If you settle a case after August 31st and there is MCARE money, it is not going to be paid until the following year on December 31st. So just be mindful of that. And from the defense side, make sure that you're notifying MCARE, notifying them early, and providing them with the information that they need to evaluate the case, because if their money is going to be involved or is potentially exposed, they need to have the opportunity to fully evaluate the case. And also one last thing about the lien letter, we had talked, Jim had mentioned liens from the plaintiff side and making sure that you know what the lien is. There is a letter that MCARE is going to require before they will engage in any negotiations that sets forth that you have made that inquiry, you know what the lien amount is, and that lien will be satisfied with any settlement funds.
Yeah, and that goes back to what we said, have that information or at least begin your investigation early. I used to use a lien company, and I stopped doing that. I just do it myself because half the time they don't get it right. And a lot of times some of your liens, it's not 100% of what they're claiming is actually repayable. Some of the treatment would have happened regardless of any alleged negligence. Make sure that you that you dig out only those claims that are related to the negligence, and then make sure your expert looks at them and says that they were reasonable and necessary expenses, because you could very well have that lien information kept out if there's nothing actually identifying what claims or what bills were related to the negligence as opposed to just the hospitalization, for example. If you get past all that, and anybody who wants this, if you can't find it, I can send it to you. There's a committee opinion that talks about what you as the plaintiff's lawyer can and cannot confirm on behalf of your client. Sometimes the lien letters that'll be sent to you will just have say, I'll make sure that the client does this. That actually puts you in a little bit of a conflict potentially. So my lien letters, I always attach this committee, and then I will just say the client, because they're going to sign the release anyways, say the client agrees to confirm with this language in the release. And that way you're not putting yourself in the middle of having to karate chop your client to do something, and then they get sore at you because they're telling you that they don't want to do it. Remember, anybody who walks into a plaintiff's office is by definition litigious. So they may be your best friend, and then things that can change later. So when you write your lien letter, make sure you always attach this committee opinion. And if anybody wants it and can't find it, I can email it to you.
And I think that's it for Jim and I.
Thank you, Carolyn, Jim. That's really valuable tips, especially not only just for those who are new to the Philadelphia program, but I think helpful reminders for those who have been here for a while. Someone who's new to Philadelphia, but not new to medical malpractice cases, is Clare Bello. Clare is an attorney, started her career as an attorney, and then delved into the world of claims management. She owned her own company for many years as a third-party administrator, and has come to Philadelphia to take over an inventory, very significant inventory at Jefferson. It's been a pleasure to work with Clare and to get to know her and her claims philosophy better. And so I would ask that everyone, I know we have a few hundred people that are still on the call. I'd like you to hang on until both Beth and Clare have made their presentation. And so, Clare, if you want to introduce yourself briefly and your thoughts.
Thank you, Judge Anders. You did a great job introducing me. I practiced law as a trial attorney for 14 years, and I owned a national medical malpractice claims company for 22 years after that. So I started practicing law when I was about 5, just so we're clear. But I worked solely with healthcare programs. I worked solely with captive and self-insured programs across the country. And so coming to Jefferson puts me in a unique position of knowing the insurance, I know the law, and I know healthcare. So it's a pleasure to be here. I want to take a moment to thank Judge Anders and Judge Schulman for the time that we've had to spend together since I've come here. I feel like I've learned a lot about the program here. I've learned a lot about the jurisdiction. But more importantly, I think we've had some really meaningful discussions that will help us ultimately try to resolve some of the cases that we deal with. One of the main topics that we've talked about has been the ability to open communications between the parties. And that's been sort of the theme of everybody's conversation today. But one of the things that I've seen across the country, it's not just Philadelphia, but there's a perception that healthcare is motivated by corporate greed mostly. and that there's a lack of caring about the people who are there in the facilities being treated. And I respectfully disagree. The vast majority of the people who are involved in these cases are people who have dedicated their entire lives to caring for others. Are they human? Yes. Do they make mistakes? Yes. Are the systems at the health system, are the systems we work in under the health programs also flawed? Yes, they are. And people do make mistakes and people do get harmed. But there's never an intent to harm. And I think that if we could move more toward a focus on negligence and error than intent to harm or greed, I think a lot of these cases could resolve much more quickly. There are absolutely plaintiffs who've been harmed and they should be compensated. It's equally important to understand that there are also plaintiffs who have not followed their healthcare plan and that there are cases that we don't believe have merit. But where there is potential liability, there needs to be an avenue to have a conversation to resolve the case that recognizes the humanity that exists on both sides. One of the important concepts I've applied is I've worked in high-risk venues for the last 20 some odd years. I've been in Cook County, Queens County, all over the US. But one of the first things that I try to do is stabilize how we're looking at the value of a case and how are we approaching the negotiation of trying to resolve a case. I've taught courses on this too. I consider valuing a case part science, part art. The science part is, what did we lose? What hard damages do we have? Medical bills, future medical care, lost wages. Those are all things that we can see, touch, and gather quite quickly. The art part is more of the subjective harm and the pain and suffering that the patient and their family may have suffered. While this isn't a number that's written down anywhere and it's not something that can be pulled in an invoice, it is something that should be related to what we can pull in an invoice. So in some places we do have multipliers because of the severity of the case or the jurisdiction that we're in or the cost of living. But the damage calculations should be intended to compensate the injured person and their family. And I think we can all agree on that. What it shouldn't be is a number that's exponentially increased simply because it's been brought here in Philadelphia. At Jefferson, we're beginning to value cases based on these concepts and not the concept that a case is expensive just because it's here. We want to be fair in legitimate cases, and we want to work to resolve those cases, but those cases need to be valued with some reasonable connection to the actual facts and damages. So if I talk a little bit more about how we're approaching resolutions, I have made a commitment with the judges to work to resolve cases that we can resolve sooner. And we are committed to that at Jefferson, and our defense panel is committed to that as well. We're looking to look at our cases more objectively. We're looking to we're looking for earlier evaluations of what we think a case is worth. And we're prepared to engage in earlier mediations, earlier arbitrations, high-low arbitrations. As Jim mentioned earlier, let's talk about cases where we think there might be liability before we're at the courthouse steps. Because the flip side to that is here at Jefferson with the new senior leadership that's in place is that when we've put a value on a case, and we're willing to share that value with Judge Schulman and in the appropriate time. And we're willing to work with the JTPs and all of the early resolution concepts. But the value is essentially the value. Unless something changes in a case, we're not going to be particularly inclined to add more money just because we're picking a jury. By the same token, there are cases we don't think have a settlement value. And those are the cases that Judge Schulman mentioned earlier of no pay cases, and those are the ones that we're likely to take to trial. We want to stay away from filing motions for the sake of filing motions. We're really trying to reimagine how we are approaching discovery in these cases. Discovery tends to be weaponized in high-risk venues, and I'm seeing some of that here. And I'd like to move away from it. I'm excited to hear about the committee of attorneys from both sides of the bar who are working with the judiciary here to develop some standard discovery requests. I think if we can move away from the very long, onerous document requests and discovery depositions of 30 some odd people in a case, I think we do get to the heart of the case faster. I do think we get to the ability to get an expert review faster. I think we get to a settlement table faster in the right cases. So I'd love to get some consensus when we're heading into discovery. I'd like to have conversations with plaintiffs' attorneys. If there are 17 policies you think that you need, my attorneys would love to have that conversation with you to find out what it is that's driving that, and maybe we produce it. I would like to get away from the motions court. Nobody wins that battle. The claimants, the plaintiffs don't win it. We don't win it. Our doctors don't win it. It is just an incredible drain on resources here in the health system, resources within the law firms, and resources within the courts. So that's a long way of saying I come to this with a little bit of a different perspective, I think. I know that there are cases that we will always fight over because that's the nature of litigation. But I do think the vast majority of them can be approached a little bit differently than we have in the past. So I appreciate the opportunity to share my thoughts and my ideas. I look forward to working with all of you more in this venue. And despite what anyone says, I do believe we're lucky in this venue. We have an incredible judiciary who's ready to listen and ready to work to make things better. And that's really unique. So that's my favorite thing about Philadelphia so far. Thank you so much for your time.
I will tell one anecdote or maybe two anecdotes about Clare. We met with her a few weeks ago at Jefferson, and she had said that Judge Schulman had recently held a one-year conference on two different cases, that during the one-year conference, there was a discussion of the demand by the plaintiff. And as a result of those two discussions, the Jefferson was able to successfully resolve both of those cases shortly following the one-year conference. And so they're prepared to be reasonable and to pay when there's liability, when there's negligence. On the other hand, Clare also relayed that she recently appeared in Philadelphia's City Hall in a trial, and the plaintiff lawyer was very happy to see that the person with the money arrived. But she didn't have any money. That was a no-pay case. It was a case that they believed was defensible on the medicine, and consistent with that, there was no offer. So she'll be there, but the offer won't change, I think, is what you're hearing. The offer, at least for Jefferson, if it's X at the pretrial conference, it will remain X unless there's some reason to change it from X. And you have to convince her that it should be changed. And that sort of consistency, I think, is going to help at least understand where Clare and the Jefferson team are coming from. So Beth Persun, if you don't know Beth, really, what are you doing in Philadelphia or in the state? Beth Persun is a jewel of our medical malpractice community. Some people have said, do you remember what law school Beth Persun has attended? The answer is she did not go to law school, but she is as agile and knowledgeable as anyone on this call on medical malpractice issues. So with no further introduction, Beth.
Thank you, Judge Schulman and Judge Anders, and thank you, panelists, because I think, you've been able to, we're only down to a couple of minutes left here, and I appreciate, and it's appropriate that MCARE would be at the end, because we most often are coming in these larger settlements at the end of negotiations, and that's where we get involved. But you've covered a lot of what I wanted to talk about in terms of getting information, getting things earlier, and the efforts that the court has made, the relationship we have with the court, and just the immense communication amongst all the parties. And it's just critically important, especially in 2024. So we want to be a source of information and ideas to insurers. We have insurers who are new. Maybe they're on the call right now. I hope they are. We want you to reach out to us so we can help you better understand how medical malpractice functions in Pennsylvania, because the fund is an unusual element. Also for healthcare providers, plaintiffs, and defense, getting your cases to the right resolution at an earlier point. So I have some things to cover. I want to cover the MCARE 2024, 2025 information, but I think in the interest of time, I'm going to jump ahead to the resources that Judge Anders referred to that I would be able to share on what can MCARE do to help the parties, and some basic information about MCARE. I thank Carolyn and Jim for introducing some of those, because Jim had reminded me we have a lot of people on the call who may not be familiar with how MedMal goes in Pennsylvania. So jumping ahead to claims, because we review most catastrophic injury cases across the state, many have great complexity. We have that concentration and that more of that knowledge of settlement resolutions, what's occurring in trials, the attorneys on both sides, and the insurers that are involved. And so we want to be able to convey information to you about those collective experiences. We have ways in which you might not have thought of that you can approach your case, and along the case continuum, not just at the end of the case. Everyone seems to forget that, settlement might be coming. Do that earlier evaluation, get that notice to MCARE, and get us involved. Keep sending us information. We're going to compile it. We're going to be reviewing it, but we can't do anything as those involved in MedMal know until we have a tender, not monetary wise, but we can collaborate on strategy and we can talk about values, and the potential outcome, as long as the case is reported to us. And I think we would all agree that the more information you have, like how can you not have more information? It's just, we're all busy, but if you can share your information, have those conversations before an event like trial occurs or a co-defendant joint torts out, you've now limited your options that we may have been able to help you with in determining. So we see lost opportunities, especially over, this is something that my staff has had to deal with, and they've done it very well, but opportunities lost by mostly the defense, by not considering those alternative strategies, because the time pressures are now on them. And we could have had a circumstance where that collaboration and getting everyone's views out can really help facilitate communications. One of the things that the MedMal folks on the call are aware of is that MCARE with mediation and binding arbitration, that is heavily used in Pennsylvania. And since 2003, which is when that whole program began, we've promoted these methods, and we have done over 2,800 processes. That's pretty impressive. I think we have more than, I don't know, probably some states could rival us, but certainly in Pennsylvania and MedMal, and they're catastrophic cases. Last year, we did 100 mediations that we were involved in and 50 binding arbitrations. And these alternative processes can really resolve the most complex cases that are at high value. And on mediation, I do want to, and I'm keeping track of my time here, on mediation, at least one party should come to the table with money and an effort to continue to globally resolve the case. It's another uniqueness about MedMal. We have more global resolutions, and that takes the case off of everyone's plate, including the courts, and leaves open, more room to be able to get the case resolved so that everyone is satisfied. With binding arbitration, There are detailed agreements that all of the parties and the payers sign, and MCARE drafts those and circulates them. Not to pick on Carolyn and Jim, but they've both been involved in those, and I think they would agree that they are successful in getting a compromise that everyone can agree on. So there's a lot we can tell you at MCARE. Leslie Lucy is our mediation and arbitration coordinator. We would invite you to contact us so we can share with you those strategies. Getting back to the numbers, and it gives you an idea of what is happening with the MCARE fund and what is occurring with the backlog that had occurred. How did that all get resolved? Because we are nearing that point. So in 2024 claim year, which was September 1st of 2023 to August 31st of this year, that those settlements will be paid to claimants on December 31st. They total $275 million, comprised of 583 claims, representing 395 cases. Now, the 2023 claim year was $242 million. And between 2019 and 2024, excluding 2021, because much like the court was mentioning, 2021 was that down year, and we really don't use it statistically because it will throw a curve in there. That average was $210 million. So you can see that there's been a progressive increase in claims that have occurred over the past 3 years. Now, the clearing of pandemic cases is largely, this is what this represents. Then that's across the state. And the last 3 years of 2022 to 2024, the overall increase, which is now at 275 million, has now borne out that has nothing to do with the change of venue rule. We haven't reached those cases yet because we come in at the end of settlement. So we will certainly be affected by that coming up. But Philadelphia County is the highest volume, not surprising, because it is the highest concentration of population and healthcare systems in the state. So we expect that. 2025, so we just started, and we have since September, and we can say our staff continues to be very busy with no sign of slowing down that we typically see with the August 31st deadline. With a few minutes left, I want to turn my attention to something that's probably going to interest more the insurers and their attorneys on the call, and that is MCARE, as you know, is a pay-as-you-go system, with our claims payments from the preceding claims year being the largest factor when determining our assessment percentage. The assessment rate for the participating healthcare providers who pay into MCARE is calculated in the fall of every year. And the rate for 2025 is 29%, and that was just published in the Pennsylvania Bulletin at the end of October. It represents a 3% increase over 2024. The increase is in part a reflection of the pandemic that slowed the payments in the court and the insurance company activity. We had that low year of 2021 of 141 million. So we had a 12% assessment rate. So if we didn't have the claims to pay and the rate went down, now we've had those 3 years where it's come back up. And so that's the result right now of the 2025 assessment rate part of it. So with that, I just want to thank everyone and say again that if you would please get us information, and we can accommodate and help you and strategize to negotiate your cases. We want to be a resource for you. And so we hope that you'll be in touch. And thank you all.
I'll tell you, thank you, Beth. One new protocol that we're adding, and it was discussed by Judge Schulman, is during the pretrial conference. if you have provided notice to MCARE of a claim, we are going to require that you send those pretrial statements that you've worked so hard on and so proud of for both the plaintiff and defendant to send them to MCARE. We have, I was surprised to have learned that there are cases that are going to trial or close to going to trial where all Beth has is a notice of claim. And she's just, and her staff are better prepared if there's more consistent flow of information to MCARE. You don't have to give her your private confidential evaluation of the case, but the pretrial statements, the expert reports, all of those are going to be important to share with MCARE so that they can fairly and efficiently evaluate cases without working weekends and without working nights. And we've met their hardworking staff. Judge Schulman and I went to Harrisburg last summer to meet with them. They are good public servants. They're not working at a big firm. They're not executives working at an academic health center. They are good state employees, and they are doing their level best to evaluate cases. And the more that you can give them information up front, the better off that they're going to facilitate an early settlement. And I'll end on this. There was a question about trial dates, and what about trial dates in 2027 or 2027, 2028? We are so far beyond. That was a potential 2+ years ago. That was a potential. And I am so proud of the team that we have here with all the groups of lawyers and clients that have worked together to handle this inventory and to do it in a way that provides justice, but also keeps an eye on case management and timelines. Because I have a responsibility to the Supreme Court. I have to report on every single case that's 2 years over and that's 4 years over since the date of initiation. And they look at those. And so no case gets better with age. We want to move these cases as quickly as we can. And I'm very proud that we have returned the Med-Mal program to a model of efficiency, not only for the state, but I think the country. So I don't think that there are any other questions from the Q&A. Does any of our fine panelists have any final thoughts?
Got to hand it to the court for getting this back aligned and back on track in such an efficient manner. I mean, I don't think that the lawyers appreciate how hard the court has worked, and we need to be thoughtful of that. So thank you, guys.
And a thank you to our partners, the Philadelphia Bar Association. I know that Jen Coatsworth, the chancellor, had to leave, but we couldn't be more proud of working with the state civil section, the Medical Malpractice Liability Committee, and everyone over at the Philadelphia Bar Association. They've been a great partner. I've been with them every step of the way. So on behalf of the Bar Association, if you are not a member and eligible to become a member, join. It's a great organization to be part of. And I think with that, we will conclude it.